All right, this is in the matter of the people of the state of Michigan versus Harold Glenn Tate Jr. We have two files, 22-20934FH and 22-21132FH. I have Tamaris Hennigan appearing on behalf of Mr. Tate. This is a date and time scheduled for probation violation hearing. Ms. Hennigan, have you had ample opportunity to speak with your client as well as the probation department?
I've not spoken with my client yet, Your Honor, but I'm just going to be asking for an adjournment. I'm going to visit him this afternoon. So,
do you want to have a breakout room with them? I have the time to allow you to do it now if you want a breakout room, or do you wish to go in person?
I'll go in person, Your Honor. I'm
All
confident in our rapport. I'll go see him in person.
No, I just meant if you wanted me to facilitate it now, I can do that. That's all. All right. So Mr. Tate, your attorney is asking for an adjournment so she can get into the jail to see you today. How far of an adjournment do you need?
Your Honor, I spoke with probation, and probation would like to see what happens with the sentencing in Hillsdale that's scheduled for March 8th, I believe they told me. So because that will impact their recommendation to this court. So if we could have like a 30-day adjournment, then the probation department and I believe that we can come to a resolution on this case to be able to bring to the court.
All right. Miss Adams, do we have anything available the 14th, the 15th, the 21st, or 22nd?
How much time do you need? Half hour?
Yeah,
just like today, yeah.
We could do a 9 a.m. March 14th.
Are you available, Miss Hennigan?
No, I have a divorce mediation at 9 a.m. that day.
8 a.m. March 19th.
Yes, that'll be fine.
All right. So, Mr. Tate, we will see you back on both of these files on March 19th at 8 a.m. All right. Your bonds continued. Thank you.
Thank you, Your Honor. Have a good day.
Thank you. And if you need to talk to me and Mr. Jones about this together, you can just set up a time.
Okay. Thank you. I will.
All right. All right. Thank you. Okay.
Hey, Rhonda, how you doing?
All right, Rhonda, Sam's the one with no picture, but he's talking to you.
Oh, hi, Sam.
She's ignoring me as usual, Judge. So
I didn't hear you.
All right, we are on the record in the matter of the people of the state of Michigan versus Shannon Lee Overton, file number 23-21245FH. I have Rhonda Underwood appearing on behalf of Miss Overton. So, Ms. Underwood, you received a copy of the probation violation recommendation and report.
We did, Your Honor.
Have you had an opportunity to review that with Miss Overton?
I have.
Miss Overton, you've had ample time to read through that and discuss it with your attorney?
I did, Your Honor.
Are you satisfied with Miss Underwood as your attorney and the advice that she's given you?
I am.
All right, so Miss Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the probation violation report?
We do not, Your Honor.
Before the court passes sentence, is there anything you'd like to say on behalf of your client? Miss Underwood, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. Miss Overton apologizes to Miss Teskey in the court, Your Honor, for not being successful at drug court. Your Honor, she apologizes for that. And it's through no fault of Ms. Teskey's or yours. She also understands that she needs to pay for her violation. Getting new charges is never appropriate. She understands the recommendation of the court and that she will continue to be on probation. And we would ask that the jail sentence be kept to a minimum in this matter, Your Honor.
So Ms. Overton, do you want to be kept on probation or do you want to not be on probation?
No, she wants to continue on probation.
Rhonda, I'm talking to her. Because Ms. Overton, you want to move to live with your mother, right?
Your Honor, I do.
Is there anything you'd like to say on your own behalf? Because I don't know that the court's inclined to follow the recommendation.
Whatever the sentence will be, I will understand, and it is fitting.
Do you think there's anybody able to pay your fines and costs for you?
No, there's not.
All right, anything else, Ms. Overton or Ms. Underwood?
No, Your Honor.
All right. Well, it's a sentence of the court that you will serve 9 months in Lenawee County Jail. I'll give you credit for 166 days already served. You can be released upon the payment of $1,398, which is what is owed because nothing was ever paid. And I'm going to revoke and terminate your probation. So your probation will not be continued. So ma'am, you have 9 months in jail, 166 days credit. If someone pays the $1,398, you get out right away. Otherwise, you'll serve that time period, all right?
Thank you, Your Honor.
And you have the right to appeal this sentence, and we're going to send over to you at the jail your notice of right to appellate review. You're going to sign 1 copy for our records, and the other 2 are for you. If you wish to appeal the sentence, you would fill out the information and mail it to the address listed on the form. Ms. Overton, I know you don't want to be in drug court, but you got to do something, or you're just going to end up dead. You know that, right?
Yes, I know that.
So I hope that you take the initiative on your own when you move to Jackson County to get into programming to make changes, because you're on a very dangerous path.
Okay, thank you, Your Honor.
Great, thank you, Ms. Overton.
Thank you, Rhonda.
Good luck, Shannon.
Thank you.
Ms. Underwood, Mr. Davis is down in lockup. Are you gonna go talk to him? Or are you good?
Yes, I'll go right now, Your Honor.
All right, who's your prosecutor on that file?
Ms. McClure, I believe.
Thank you.
You have reached Kim Case with the Lenawee.
Judge, do you want me there in person on Aaron Carr?
On who?
We're doing a bench conference on Aaron Carr. She's in custody.
Right, I have her down for a bench conference and a pre-trial.
You
Which
want
is
me there in
interesting.
person?
I don't care. She's not gonna be here in person, but I gotta find a prosecutor, so let me see if I can find a prosecutor.
I think it's Isaac.
Answering the phones. Let's see. Yeah, oh, somebody was watching YouTube. No. I also need Isaac Sneed, I believe, on Aaron Carr.
Oh, that's me too. I'm sorry, I was running late this morning. I was trying to get an amended done on.
It's okay. So Mr. Malaro, Ms. McClure is here in person.
All right.
All right,
Let me pop over, Judge, if you don't mind.
I don't mind.
Okay.
And
Okay.
Mr. Marshall is here on Israel Gooden. He's at 8:30. So is he gonna zoom in, Mr. Marshall, or
I'm not sure. I've lost contact with him, so I can waive his appearance.
okay. Okey-doke. All right. All right, I'm gonna step off the bench while we're waiting for people.
Morning, Phoebe, how are
Good
you?
morning, I'm good, how are you?
Good, thank you.
But has Miss Underwood already been here?
She was downstairs, she's coming up now because, there's Davis.
Yeah.
Here, yeah, she's on her way up.
All right, I never heard from her on that yesterday, so I wasn't sure exactly what she needed from me.
Oh, okay, your necklace is beautiful.
Oh, thank you. Oh, no. Now the county Wi-Fi is not working.
Oh,
Madam Clerk, are you in the courtroom?
I'm the court recorder, Mr. Marshall, may I help you?
Yeah, I had a motion hearing in front of the judge on a Jake Klein on February the 1st. And the judge had a jury trial. So she just said she would just read the briefs and issue a written opinion. I'm just wondering if that was ever done.
Oh, I don't know, Mr. Marshall, you might want to reach out to Becky, that's her judicial assistant. I can give you her email or phone number.
Yeah, give me both, please.
Okay, certainly, the number is 517-264.
264.
4577. And the email is Becky, BECKY. Dot Adams, Adams,
ADAMS. Okay.
at Lunaway.
Okay.
.mi.
.mi.
.us.
Okay, thank you.
Okay, you're welcome, sir.
My internet's not working.
It's not,
No. So I can't pull this up.
do you want me to check to see what the Wi-Fi password is or anything?
Yeah, maybe it's
Okay,
different
yeah,
now.
Let me.
But it says connected and it's just not,
Huh, okay,
you know, it's not working.
right, okay, let me check for it.
You never responded to me yesterday, so I didn't.
Oh, I'm
know.
sorry.
No, that's okay. Sorry. Was there some reason we put this over from yesterday instead of today? Or-
He wanted to be here.
Okay.
That,
Did you need anything more from me other than?
No.
Okay,
but he just wanted to keep the no copy.
okay. My internet's not working, so I can't pull up his file. All I have is his amended information.
Okay.
Do you have anything, any police report or anything?
Well, I have his police report, but I don't know how I could get it.
All rise.
Are you ready for him?
What have you,
We need a police report for the plea and the county internet stopped working, so I can't pull it up.
Okay.
I have it on my screen.
You what?
I have the police report on my screen.
Okay,
Do you want me to bring it in and you can?
well, I don't read the police report. That's up to you guys to do.
23.
Yeah, the
Oh,
password's
okay,
right,
gotcha,
it's
okay.
just, it's saying connected, but then it doesn't load anything.
Oh, gotcha, okay.
If you email it,
Yeah,
can you email it to Becky and we'll print it off?
Sure. I'll do that right now.
All right, Becky, Rhonda's going to email you a police report. We could print that off, or,
Okay.
I mean, it's not really a hard case.
no,
So,
and the only other issue is I can't get the plea agreement,
But you can put that on.
yeah, yeah. I,
You can sit down, I'm sorry. Okay,
I'm sorry, I was gonna do all this yesterday and then I had emailed Rhonda and then I never heard from her.
Are you here in Gooden too?
That should be Jen.
All right.
Is she logged in?
Not yet, but it's just now turning 8:30.
Okay.
Oh, there she is. All right, now I have Ms. Bruggeman. Okay, this is in the matter of the people of the state of Michigan versus Israel Lewis Gooden, file number 2022-21179FH. I have Jennifer L. Bruggeman appearing as Chief Appellate Prosecuting Attorney, and I have Hugh R. Marshall appearing as Appellate Counsel, I believe, from Mr. Gooden, who, Mr. Marshall, you said you have lost contact with Mr. Gooden?
Yes, Your Honor. As far as I know, he's still in MDOC, but I was unable to locate him. Their website is down, so I couldn't.
Yeah, all of Otis is down right now, so no one can access any of it. Yep. Okay, so, Mr. Marshall, we're here on your motion to withdraw the plea.
Yes, Judge. It's Hugh Marshall on behalf of Mr. Gooden. Your Honor, it's pretty straightforward. If you read the numbered paragraphs, basically my argument is that during the taking of the plea, Mr. Gooden expressed dissatisfaction with his attorney, and he said he was reluctantly accepting the plea offer. Then there was an exchange between the court and Mr. Gooden. And I'm quoting, "Okay, this is you, Your Honor. Okay, Mr. Gooden, are you satisfied with Ms. Underwood as your attorney and the advice she's given you?" And he responded, "Not really, but I'm taking it anyway, though." And then you responded, Your Honor, "Okay, so you're not happy with the plea offer." He responded, "There's been promises broken and that it ends there." I think there was a break, and you explained to him that the attorney was not the case, but she was his attorney. And then the court accepted the plea and we went on from there. And then at sentencing, he.
Well, it also went on and I said, so you are satisfied with what she's done? She's not the case, she's your attorney. So are you satisfied with what she's done for you so far? And he said, yes. Right?
Agreed. Yeah, agreed. I didn't put that all in there, but yes, you did say that, Judge. And then at sentencing, he again said he was dissatisfied with his attorney and the advice you've been given. He went on to say he wanted her to file a motion to vacate. He was not notified. He didn't consent to the adjournment of the previous sentencing date. However, you took that into account in the delay in sentencing when you did sentence him to the lower end of the guidelines and did advise him that this sentence would run consecutive to the other sentence because he was in MDOC. So basically, the argument is it's not a knowingly, understandingly, or voluntarily made plea because of his dissatisfaction with his attorney at the plea stage and its sentencing. And I just argue based on the case law that it wasn't a voluntary plea.
Ms. Bruggeman?
First, Your Honor, I know that we did do a writ. Did we attempt to contact MDOC or no?
So I
I mean, it doesn't matter to me, and if Mr. Marshall wants to waive his appearance, that's fine. I just wanted to make sure that the court was aware that we did do a writ and that they did confirm it, so.
So I know that you did a writ, and I know that all the computer systems for MBOC are down for restructuring or something, so I don't know. I mean, I'm more than willing to adjourn this to get Mr. Gooden here.
No, Your Honor, I can waive his appearance.
Okay, all right, so Ms. Bregman.
Your Honor, I I filed an answer in a brief. I think that pretty much addresses the issues. I mean, really, when you look at the entirety of the plea transcript as well as what was said at sentencing, I think it's actually pretty clear that it was a plea in compliance with MCR 6.302. There's nothing that has been presented that would indicate otherwise, other than that brief statement that he wasn't satisfied with her representation or her advice. But really, when you get into the heart of it, into the transcript, he was very well aware of what the plea was, that the COBS was no more than 12 months. He understood all of that. He didn't have any questions about his trial rights. He didn't raise any issues at sentencing as far as that the court was complying with the plea agreement, or that he had a problem with the plea agreement. Yes, he did have a problem with the adjournment, but one denied his motion, if you will, his verbal motion, that he was prejudiced, and he was not, and you took that into consideration. So given the entirety of the record, there's just nothing here that would indicate that he is entitled to relief. So I would ask the court to deny the motion.
Anything else, Mr. Marshall?
No, Your Honor.
Oh, wait, they might have brought him in. Here we go. I got MDOC. So let's see, they just popped in. All right, Mr. Gooden? Who do I have from MDOC?
Mr. Gooden, can you hear us?
I can hear you. Can you hear us?
Okay. Yes, we can.
All right. Okay, so Mr. Gooden, can you hear me?
Yes.
All right. So, Mr. Gooden, we are on the record right now in the matter of the people of the state of Michigan versus Israel Lewis Gooden, file number 22-21179FH. So, counsel, I do apologize, but now that I have Mr. Gooden here, Mr. Marshall, we're going to start over again. So, Mr. Marshall, can you present your motion?
Yes, Your Honor. As indicated before, Mr. Gooden wishes to withdraw his plea, and if the court does grant that, then he would be granted a new trial. I base that on a lot of the colloquy and discussions, conversations during the taking of the plea and its sentencing. And basically, Mr. Gooden on multiple times said that he was reluctant in accepting the plea offer. He was dissatisfied with his attorney and the advice that he was given. And again, he expressed that same remorse and that same dissatisfaction at sentencing. We did discuss before Mr. Gooden arrived here that the court, there was a delay in the sentencing, and the court did take that into account when you sentenced him at the very bottom of the guidelines, and you did advise him the sentence would run consecutive to his other sentence because he's serving an MDOC sentence. So basically, the argument is he did this reluctantly. It's not knowingly, voluntarily, or understandingly made because of his dissatisfaction with his attorney. And he used the word, I'm trying to find if he used the word reluctantly or not, if that was my word, but he said there was promises broken. He wasn't happy with his attorney. And I just think if you take the totality of the circumstances, then that would show that he didn't enter into this knowingly, voluntarily, and understandingly because he did it reluctantly and not fully understanding what was going on.
All right, Ms. Bregman?
Your Honor, again, I believe that the record, when you look at the entirety of it, it does not support withdrawal of the plea. Yes, he did make that initial statement during the plea that promises were broken, but then you went on to clarify with him that he was satisfied with the advice that Ms. Underwood gave him, and then you went through the typical trial rights and what he was giving up with regard to the plea, and you also went over what the Cobb's agreement was. And he indicated that he understood those terms, even when he said that he believed that the guidelines were 5 to 17 months. You clarified again with him that could be the case, but you hadn't ran them, and that you agreed per the Cobb's agreement that it wouldn't be more than 12. And so again, he understood that all those terms. At no point, again, did he indicate what those promises, alleged promises were that were broken, but I think, again, given the totality of the record, it was a knowing and understanding plea, and an accurate plea at that. And so again, then when you go to sentencing, when you look at sentencing record, the court complied with the Cobb's agreement. There was no indication that he wanted to withdraw the plea, that there was anything that he was promised or anything of that nature that would induce him to have pled. And so again, also there was no motion even after sentencing. I mean, there's this one, but no indication at any time that there was a defect in the plea. So I would ask the court to deny the motion.
And Mr. Marshall?
No rebuttal. Thank you, Judge.
All right. So Mr. Gooden was originally charged with count one, prisoner possessing contraband, which was a 5-year felony. He has a habitual offender fourth offense notice, which would have made conviction at trial a life offense, which means he would have served life in prison on the new offense. Miss Underwood, I think it was Miss Underwood, was his attorney at the time, and she and the prosecutor reached an agreement for a plea, and then there was an agreement on sentencing. I reviewed both the plea transcript as well as the sentencing transcript. And one thing I will say is that I look to both what is in the best interest of the defendant as well as what is in the best interest of victims in my court, because that's my job. So I'm always very thorough with people that come before the court, making sure that they understand the rights, they understand the plea and the impact on them. And so, Sarah, can you mute yourself? So when Mr. Gooden expressed any concerns, we did discuss those, and he made it very clear that Miss Underwood had made a good faith effort on his part and did what was expected of her, but that he perhaps wasn't as happy with the plea. And there was the issue, and he questioned why he wasn't present for the original sentencing, and whether there wasn't a writ done or something of that nature. We have struggled sometimes to get people from MDOC, and so we adjourned it. And then I gave him credit for that time period because I felt that that was fair. So upon review of the transcripts and the motions, the court does not find that the defendant has demonstrated that he's entitled to withdraw his plea under MCR 6.310C. And therefore, I will deny your motion. All right. Thank you. Thank you, Mr. Gooden.
Thank you, Judge. Would you like me
Thank
to
you, Your Honor.
prepare an order and submit it?
Yep, you can prepare an order, please.
Thank you. Okay, Mr.
Thank
Gooden, I'll
you.
be in touch.
You're all set, Mr. Goodman. I'm gonna now remove you. Okay. So I have did you send an amended felony information for today?
Yeah, is that what she handed you?
Yeah, she handed me an amended information as well as a police report.
Police report's just for us to put the plea on the record.
You hand that to me.
And I also sent the plea agreement because it came back.
I got that.
Okay, did the amended information have count 3 and 4 on it?
Yes.
Okay, because the first time I had a typo that said 4 and 5, so I did correct it.
I think that's correct. Because it said 4 and 5, not 3 and 4.
No, I got 3 and 4.
Okay. I didn't get that.
What are you talking about, John?
Mine says 1, 2, 3, 4, not 1, 2, 3.
Yeah, she said she just corrected that
Okay,
typo.
okay,
Yeah.
okay.
All right, okay, so, and get rid of MDOC. And yeah, lots of Jones. But are they bringing Mr. Davis down? Well, I don't know where Rhonda is.
I'll show you here.
Yeah, I'm ready for him, so I don't know if she's down there with him.
No, she said she was done.
All right, well, Sam will text her. And
Yeah,
you'll
the
get
phone-
Mr. Davis
Judge, her
right
phone- Judge, the phone's right here.
See if she's in the jury room. Might be in the jury. She's down with Judge Olsaver, so they can bring him down and we'll just. Okay, so there's Davis. You guys are on car.
Yes.
You want to go talk about car?
Good.
I mean, isn't it a bench conference?
Yes.
Sure.
We can go talk about car. This way. Brenda's in court.
He's bringing Mr. Davis down. So this-
Yeah, I think so.
Oh, I thought it was like-
Maybe it's not, maybe it is ice and stuff this year. Oh, yeah. You guys all, I know you. No, right over at that table. Okay.
Sir. Oh, that's fine. We're ordered. I guess this is what I thought. I can see it over there. It's like it's a church. Yeah.
Yeah.
I guess if that will work.
Oh,
Thank you.
Morning, Justin. How are you? Good, good, thank you.
Yeah, sure. Yeah. We'll get them all before it. There's some policy, just have some policy. Just take a look. Down there, yeah, in my desk, so I'll after lunch or something. I'm not sure if you signed them already. I don't yet. If you had no. I know. Okay. Yeah. Yeah, I do. There's a 7 years in March.
All rise.
Deputy Frost, Ms. Underwood zooming, so she'll be in just a minute. Huh? She should be coming in. Jeff, hold on. Do you wanna, Mr. Mallow, could you?
She's down in your jury room.
She's in my jury room and see if she's available to pop in real quick.
I'll tell her she's about to be held in contempt.
It'll only be like a minute or so. Hi, this is Judge Anzalone. How are you?
Good.
Could I get Aaron Carr?
Sure.
And, I think once I get Aaron Carr, that's my last one for the jail list this morning, so. All right, thank you.
All right.
Bye. Ms. Teskey, if I were to sentence somebody on a misdemeanor and they have an extradition hold from another state, if I sentence them, as long as my paperwork says they could be released, then the other state will come get them on the extradition, right? That's what I thought.
Correct, Judge. Yeah.
Eyes.
I'm just doing it right now. You can be seated. I don't know what that's. All right, Ms. Carr, I am looking for Sam Malaro. Was he on his laptop?
He was, yeah, he was on his laptop.
Well, his, oh, there he is. Okay. Okay. Now let me get Sam in. All right, Sam's gonna connect to audio. Oh, all right, this is in the matter of the people of the state of Michigan versus Erin Michelle Carr. File number 24-21709FH. This is the date and time set for pretrial in this matter of Sam Malaro appearing on behalf of Ms. Carr, and I have Phoebe McClure appearing on behalf of the people. Ms. Carr, I am going to open up a breakout room and place you and Mr. Malaro. Oh, hold on, I gotta figure out your jail window. You and Mr. Malaro into that breakout room and go ahead and join that breakout room. I'm also, Becky, you can let the jail know. I can start seeing the pickups too. So now we are here in the matter of the people of the state of Michigan versus David James Davis. File number 23-21633FH. I have Rhonda Underwood appearing on behalf of Mr. Davis, and I have Phoebe McClure appearing on behalf of the people. This was the date and time set for a pretrial in person, and Mr. Davis is present in person in the courtroom. I have received from the parties a plea agreement form as well as an amended felony information. The paperwork states that the plea in this case that has been offered is a no contest plea to count 3, unlawful use of a motor vehicle, and count 4, lying to a police officer, 1 to 4 year crime investigation. Dismiss count 1 and 2 and his habitual offenders, because he does have a 4th offense notice. So he potentially could have been looking at life in prison on count 1 and 2. And restitution would be in the amount of $500. And it doesn't look like there's any other agreement between the people and the defense. Is that correct, Ms. Underwood?
Yes, Your Honor.
All right. So Mr. Davis, why don't you, Ms. Underwood, why don't you step over closer to Ms. McClure and Mr. Davis stand at the podium so we can get audio.
And I would just ask Ms. Underwood to put the basis for the no contest on the record.
Intoxication, Your Honor.
Lack of memory?
Yes.
Okay, so the basis would be lack of memory. Do you have a question for your client?
That is the plea bargain we discussed, correct?
I thought that, it said on my paperwork it was joyriding. It said unlawfully driving away with the vehicle.
My paperwork does not say joyriding. It says count 3, motor vehicle unlawful use, which is a 2-year high court misdemeanor.
Okay, yes, that's fine, 'cause I was taking it as.
Joyride, I think
A lot of
joyriding,
people call it joyriding, but it's the.
joyriding is a separate offense with a longer penalty,
Okay.
isn't it?
It's, the actual offense joyriding is used for this as well as a 90-day misdemeanor.
And then count 4, lying to a police officer is a 1-year misdemeanor. So basically you're pleading to a 1-year misdemeanor and a 2-year high court misdemeanor.
Yes, ma'am.
All right, do you understand that?
Yes, sir.
Okay, and Miss, do you have any questions about the plea offer, Mr. Davis?
No.
All right, want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, so you fully understand the plea offer that was made today?
Yes, sir.
You understand that your plea is going to be a no contest plea due to lack of memory?
Yes, sir.
Okay, and are you satisfied with Miss Underwood and the advice that she is giving you?
Yes, sir.
Okay. And neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence in regard to jail time, fines and costs, or term of probation, correct, Miss Underwood?
Correct.
Ms. McClure?
Correct.
All right, sir, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you will be giving up right to appeal issues that would, or you would be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes, sir.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, sir.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
So, sir, and remember your choices are no contest or not guilty, right?
Yes, sir.
All right, so how do you wish to plead to the charge that on or about November 5, 2023 in the city of Adrian in the county of Lenawee, that you did commit the offense of motor vehicle unlawful use to your misdemeanor?
No contest.
Okay, and how do you wish to plead to the charge that on November 5 of 23 in the city of Adrian in the county of Lenawee, that you did commit the offense of lying to a peace officer on a 1 to 4 year crime investigation?
No contest.
Okay, and has anyone made any threats or promises to you other than what was placed on the record to induce you to plead no contest to these charges?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Ms. McClure?
None, Your Honor.
Has your attorney promised you any particular sentence other or estimated what your sentence will be in terms of probation, fines and costs, jail time?
No, Your Honor.
All right. Is it your own choice to plead no contest?
Yes, Your
All
Honor.
right, who will be placing the factual basis on the record?
I believe there was a copy of the police report.
I can do that, Your Honor.
Okay.
Your Honor, I think we are stipulating them to the Adrian Police Department report number 2311680. That report was dated November 5th, 2023, and was authored by, I believe, Officer Colin Castleberry of City of Adrian Police Department. And the pertinent facts to that report are that on November 3rd, November 5th, 2023 at 520 College Ave, which is the location of Runaway Wreck and ZZ's. A K Frost parked her vehicle, a 2010 Chevy Impala, excuse me, at that parking lot, and left her keys in her vehicle as she was getting ready to leave for work. She did not give anyone permission to drive her vehicle, and an individual left Runaway Wreck and took the vehicle, drove off in it. It appeared to be a white male, was later, through investigation, revealed that it was in fact Mr. David Davis. When he came into contact with the police, he did talk about getting in that vehicle and leaving Runaway Wreck, and started to drive home before he realized it was not his vehicle. So although not willful, he did take that without authority of Miss K Frost. And it was an unauthorized taking of that motor vehicle. Additionally, when being questioned by Officer Castleberry, he not only provided a false name because he had some warrants, but he also he refused to give them information about where the keys to that vehicle were, indicating he wanted to wait to see what his bond was going to be set at before he told them where the keys were, so that Ms. Frost could get her vehicle back. With that, I think that satisfies both count 3 and count 4.
Okay, any additions, Ms. Underwood?
No, Your Honor.
All right, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on November 5 of 2023, in the city of Adrian in the county of Lenawee, that the defendant did commit the offense of motor vehicle unlawful use by taking without authority and without intent to steal a vehicle that was authorized and owned by another individual he had no permission to take. And that would satisfy count 3. And with regard to count 4, he gave false statements to the arresting officer that he knew was false or misleading regarding material facts related to, such as, I think you said, where the car was and where the keys were.
Correct.
All right. And therefore, the court does find that the defendant did commit the offense of lying to a peace officer 1 to 4 year crime investigation, as well as motor vehicle unlawful use, which is a high court misdemeanor, and the court will accept the no contest pleas for both of those. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
And Ms. McClure?
It has.
All right. I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his right. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. We will set sentencing for May 3rd at 8:15 in the morning. Is any objection? Do you want to come in person? Or you want to be up here via Zoom? In person, all right. So we will set sentencing in person. Mr. Davis, someone from the Michigan Department of Corrections probation office is going to come over to the jail and meet with you. You don't have to speak about the offense that occurred because you did plead no contest, but be truthful with them about your background, and they will prepare a report. We'll provide that to both the attorneys. They'll review that with you before May 3rd. And then we'll see you back in person on May 3rd at 8:15. All right, thank you. Your bond's continued.
Judge, because these are misdemeanors, will district court be doing the PSI or?
No, it's a high court misdemeanor. It's a 2-year felon. It's a high court
Okay,
misdemeanor.
I just wanted to be sure.
Yeah, because count 3, that joyriding offense is a 2-year.
Okay.
So that would be you guys.
Okay, I just want to be sure.
Sarah, I can forward you the plea agreement, the amended information.
That would be great. I didn't take anything down because I thought district court would be doing that.
Yep, no problem.
All right.
Thank you.
So, yep, Mr. Malaro, I do have you and Ms. Carr back, Mr. Fry, Mr. Raines. I also have Angie Borders here as guardian ad litem on that file. We had a whole lot of pickups last night and some pleas this morning. So I can do one of 2 things. You can sit here and watch me, or I can put the 3 of you in a breakout room in case you needed to have a discussion.
I'm happy to be in a breakout room with Mr. Fry.
And Ms. Borders as well?
Doesn't
Yes,
want to.
that's fine.
Okay,
If Miss Borders wants to join us.
not really, but I'll be there.
Okay, let me see here. Mr. Raines, okay, I've opened the breakout room. I'll bring you back in when I'm ready for you, or you can come back whenever you want. All right, so we're back on the record in the matter of the people of the state of Michigan versus Aaron Michelle Carr. So, Mr. Milaro, have you had ample time to speak with Ms. Carr?
I have, Your Honor.
All right, and how would you like to proceed today with Ms. Carr?
Judge, after our bench conference, Ms. Carr is agreeable to entering a plea of guilty to an amended count 2 use of methamphetamine, and is pursuant to our bench conference, it's my understanding, the court, if possible, will sentence today, and the sentence would run concurrent to any sentence she may receive out of Indiana.
Is that a correct recitation of the plea and also the bench conference, Ms. McClure?
It is.
All right. All right, so Ms. Carr, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, I have no audio on you. So can you scoot forward and say it again?
Yeah, I do.
Okay, you're gonna have to stay up close then. Thank you.
Okay.
You can put your hand down. All right, so Ms. Carr, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count 2 use of methamphetamine, which carries a maximum penalty of up to 1 year in jail?
I do.
Okay, are you satisfied with Mr. Milaro as your attorney and the advice that he has given you?
Yes, ma'am.
All right, and let's see, neither, all right, I'm gonna pause right there, Ms. Carr, just for a moment. Mr. Reed, can you hear me? Are you Rio Reed? Are you Victor Garza?
Yes.
Okay, I can barely see you back there, so I wasn't sure who I had. All right, this is in the matter of the people of the state of Michigan versus Victor Garza, file number 2019-19399FH. Mr. Garza, we're here on 2 things. One is failure to appear for a probation, well, actually 1 thing, I think. Failure to appear for a probation violation sentencing on January 12th of 2024. The contempt of court carries a maximum penalty of up to 93 days in jail. Do you understand that, Mr. Garza?
Yes.
All right, it looks like you already pled to the violation of probation. So, Mr. Garza, I believe Ms. Underwood represented you on the violation of probation. Is that correct?
Yes.
Okay, would you like her appointed to represent you on the contempt of court for failure to appear?
Yeah, that's fine.
Okay, so I'm going to open up a breakout room and I'm going to put you and Miss Underwood into that breakout room while I'm taking care of another matter. Find you. Okay, so oh, there we go. All right, so back to you, Miss Carr. So neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Miss Underwood? Wait, where'd Rhonda go?
Oh, she went in with Mr. Garza.
Oh, wait, Sam, where's Sam at? Sam's her attorney.
Yeah. I just heard him too.
I know, I just lost Sam Milaro. Hold on. I know he's back there. Thanks, Sam, for coming in here. Yeah.
Oh, she's zooming with regards.
All right, I found Mr. Milaro.
Okay.
All right, so Mr. Milaro, no one has discussed a possible sentence with the court. Is that correct?
Other than that, it's a 1-year misdemeanor, Judge.
Is that correct, Ms. Mayor? That's correct. All right, and Ms. Carr, you understand there was an agreement and a discussion with the court that you'd be pleading to a 1-year misdemeanor, sentenced to 1 year in jail with whatever credit you're entitled to and released to Indiana.
Correct.
Okay, all right. So if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
I don't, thank you.
All right, so Ms. Carr, how do you wish to plead to the charge that on or about January 19th of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense of use of methamphetamine, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
I do, thank you.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Your Honor.
Ms. McClure?
None, Your Honor.
All right, and we've already have a sentencing agreement. So Ms. Carr, is it your choice to plead guilty today?
It is.
All right, so Ms. Carr, back on January 19th of 2024, were you in the city of Adrian in the county of Lenawee?
Was.
Yep, and did you use methamphetamine?
I did, yeah.
And you knew it was methamphetamine?
Yeah.
And you had no legal right to use it?
Right.
Are you satisfied, Ms. McClure?
Yes.
Has court complied with MCR 6.302 B, C, and D? Mr. Malaro?
I believe the court has, yes.
Ms. McClure?
Yes.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. Ms. Teskey, Ms. Carr isn't on probation, is that correct?
She was sentenced.
Your Honor,
tonight.
she is on probation with me.
Yeah.
Okay, all right, okay. Will she have a violation for this?
Yes,
Because we will be
technically,
because we're releasing her to Indiana.
okay. When is her time up for the or for the original sentence on the case that I have her on? Aaron, do you know what your release date is?
Yeah, my year is up on March 31st.
March 31st?
Correct.
All right, so this test is gonna check into that. All right, so Ms. Carr, you do have a right to have a pre-sentence report done and have this matter set for a sentencing date. That day would be May 3rd. Mr. Malaro and Ms. McClure and I had discussed that you do have the right, because there isn't a victim on this crime, to waive a pre-sentence report and move to sentencing today. So Mr. Malaro, have you and Ms. Carr discussed that?
Yeah, we did, Your Honor. We're willing to waive the PSI.
All right, so you're willing to waive the PSI, Ms. Carr?
Yes, ma'am.
Okay, all right, so before the court proceeds to sentencing, Ms. McClure, is there anything you'd like to say on behalf of Ms. Carr?
No, Your Honor.
And Mr. Malaro?
Just said she is more serious matters in Indiana, and I think Ms. Carr wants to move ahead and take care of those, and we'd ask the court compassion sentence that accomplishes that.
All right. Ms. Carr, anything you want to say on your own behalf? No. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. Hold on 1 second. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Ms. Carr, I do not have your jail credit calculated right now because I wasn't sure we were moved to sentencing, but we will get that information today. And you'll get credit for whatever time you served on this charge.
Judge, if I may, our records say 30 days.
Okay, Mr. Malaro states that you have 30 days on this file. So what I'm gonna do is sentence you to 1 year in jail. I'll give you credit for 30 days already served and allow you to be released to Indiana because I believe they have an extradition hold on you, okay? Ms. Chesky?
So I'll just serve my year there? Is that what, like?
Yeah.
Okay.
That's our intention. If something happens, the jail will let us know. Ms. Chesky, with regard to the probation, does her probation end in 30 days?
No, Your Honor, she will be on probation. She just will be done with her jail sentence with me.
Okay.
So she'll continue to be on probation. Aaron, you are on probation. So if you're released at any time from any jurisdiction, you need to come see me the very same day.
Okay, so what if I'm going to prison? I don't want to have to come back to Michigan.
If you go to prison, you will discharge on probation.
Okay, for sure.
If you go to prison in Indiana, this time runs concurrent, and Ms. Teskey, your probation will end up being terminated.
Correct.
Okay.
All right. So Ms. Carr, I wish you the best of luck in Indiana. We're going to send over to you your notice of right to appellate review. They're going to have you initial 1 copy for my records. The other 2 are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. So thank you, Ms. Carr.
And they're going to be letting Indiana know today that I'm.
Yep. The jail will get the paperwork and notify them.
All right, thank you.
Thank you. All right, Ms. Underwood, how would you like to proceed with Mr. Garza today?
Your Honor, I believe Mr. Garza wishes to accept responsibility and plead guilty to the failure to appear.
All right, Ms. Adams, do we have a PSI or probation violation report from Mr. Garza?
I have one from 9/25, Your Honor.
I have one from sentencing date of 9/28. I have one. Do you want, like, I would rather sentence him and Mr. Reed today than adjourn it to another day. So have you reviewed the probation violation report with Mr. Garza?
I believe I did back then, Your Honor.
Yes. Mr. Garza, do you need a minute? Do you need a minute to talk to her about your probation violation report, or you remember it?
I remember.
All right. So, Mr. Garza, raise your right hand for me, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so Mr. Garza, you were ordered to appear for probation violation sentencing on January 12th of 24. The allegation is you failed to appear for that. Do you understand that you have a right to have a hearing on that charge?
Yes.
And do you understand at that hearing, you would have the right to call witnesses and to take testimony? Do you wish to waive your right to that hearing and enter a plea of not of guilty to that contempt of court?
Yes.
And we appointed Ms. Underwood to represent you. Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes.
All right. And Ms. Teskey, this is a file from Mr. Stevenson.
Yes, Your Honor.
Oh,
You
it's
want me
Mike
to-
Stevenson. Well, I don't know. I'm just telling you, I'm gonna sentence him today and it's Mike Stevenson's file.
All right, hang on
All
one
right. So, Mr. Garza, did you receive a notice to appear? Well, on the record, I gave you a sentencing date for your probation violation sentencing. Is that correct?
Yes.
All right. And how do you plead to the charge that you failed to appear for that probation violation sentencing on January 12th of 24? Guilty or not guilty?
Guilty.
All right. So, Mr. Garza, you received a notice in the mail, but you chose not to come that day, correct?
Yeah, I overslept.
Okay.
I just.
Okay.
Yeah.
But you didn't come in later that day or call me, did you?
No, I turned myself in yesterday.
No, and I appreciate that. All right, so, all right, I accept the plea. It has been given understandably, voluntarily, and accurately. He has full knowledge of his rights. He does have competent counsel. So, Ms. Underwood, with regard to the probation violation report, do you wish to explain or challenge the accuracy or relevancy of any information in that report?
I don't believe we do, Your Honor.
All right, Miss, do you have anything you'd like to say on behalf of Mr. Garza before the court
Your
passes the
Honor.
sentence?
I'm sorry, Your Honor. Mr. Garza, I think, just wants to get this matter concluded. I don't think he wants to be on probation anymore. I think he would like a jail sentence. I know there was talk of a pay his fines but I don't think he's in a position right now. I asked him to pay that amount immediately. So I would ask for I believe Mr. Garza wants
The recommendation is for 15 days in jail and terminate probation.
Yeah.
Is that what he wants? Oh,
yeah.
All right. Mr. Garza, anything you want to say on your own behalf?
No.
All right, on the contempt of court, I'm going to give you credit for time served of 1 day because you did turn yourself in, and I do appreciate that. On the underlying probation violation, it's a sentence of the court that you will serve 15 days in Lenawee County Jail. And I will give you credit for 1 day already served. So, Mr. Garza, I hope that you moving out of state and starting a fresh life works for you, and I do wish you the best of luck. All right.
All right. Thank you. I appreciate
So
it.
you do, yep, you do have the right to appeal this sentence. We're going to send over to the jail a copy of your notice of right to appellate review. You can just sign one copy to acknowledge receiving the paperwork, and the other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Okay.
All right.
Mr. Garza, could you let them know I'd like to see Rio Reed next?
Judge, Judge,
Yes.
what did we
yes.
do with the contempt?
Oh, I gave him credit for 1 day already served.
Okay, got it.
All right.
And
all right.
and his probation is terminated, correct? Your
Yep,
Honor?
probation's terminated. Yep. All right, just let him know I need to see Mr. Reed next. Thank you, Mr. Garza.
All right. Yep.
All right, Sarah, I'm gonna start letting people in. I'm gonna put you guys in a breakout room, all right?
Judge,
Yeah.
what sentence date did you give David Davis?
What did I what?
What sentence date did you give David Davis?
I think it's
May 3rd at 8:15.
May 3rd. Okay.
Yep.
I'm trying to
All right.
look at my stuff to see what I have with you left.
I don't know. The only thing I have next is Rio Reed, and then I'm done.
Shannon Overton?
Yeah, we already did that.
You did it without me.
Yeah. So, 9 months in jail, credit for time. I did what we talked about. 9 months, or I gave her 9 months in jail. I gave her credit for time served of $166 and a paying out of $13.98, revoke and terminate probation.
9 months jail.
Credit for 166 days.
Okay.
Revoke and terminate.
Pay $13.98.
She got a paying out. I pulled a Sheridan.
Okay.
I did a Judge Sheridan. I gave her a paying out of $13.98 and then revoked and terminated.
Perfect. Thank you.
Okay, thanks. All right, so everybody from the specialty court, that's you. Okay, I'm gonna put you guys into hold on. Delete. All right, I'm going to assign Miss Tusky, Mr. Emmerich, Jesselyn Holdridge. Hold on. Is Rachel Dockstader part of our specialty court now? Okay.
Yes, she is.
Yep, I am. Let's see. Okay. All right, so hold on. Sign.
Yes.
I think I got everybody. Okay, so this is in the matter of the people of the state of Michigan versus Rio Ernesto Reed, file number 23-21349FH. Mr. Reed, we are here on two things. One, I have a contempt of court for failure to appear for sentencing on September 22nd of 2023. Mr. Reed,
Yes,
that
ma'am.
carries a maximum penalty of up to 93 days in jail. And then, Mr. Reed, we have the original sentencing. So I do have a pre-sentence report. Ms. Underwood, who is the attorney on this? Oh, Mr. Malaro, do you have that pre-sentence report? You should. It was sent to you on August 11 of 2023.
Dr. Me, Judge?
Yeah, this is your time.
And I did review it with Mr. Reed prior to today.
Okay.
If he needs me to go over it again, I can.
All right, so Mr. Reed, your attorney was Salvatore Malaro, who is in my court right now. So would you like an attorney appointed to represent you on the contempt of court?
Yes, ma'am.
Would, all right, so Mr. Malaro, do you want to go back in my jury room and just zoom in with Mr. Reed?
Yeah, I can do that.
Miss Underwood, I don't believe I have anything else for you today.
Thank you, Your Honor.
Thank you. So hold on, and Mr. Reed, in just a moment, Mr. Malaro is gonna log in. And I will put you in a breakout room, and I am going to go talk to my other attorneys.
Okay, thank you, ma'am.
You're welcome. So we'll try to get your contempt of court and your sentencing done today, all right?
Okay.
Miss Tusky, oh, she's already gone. All right, I'm gonna